So I used to be a lawyer for big insurance companies. I used to defend the insurance companies in court against claims brought by injury victims. I defended countless rear-end car accident injury claims in court. I now, however, represent rear-end car accident injury victims. By having experience working both sides of these cases, I've come up with my 5 tips on how to give you the best chance on winning big in your rear-end car accident injury case. To demonstrate how these tips work in a real-life case, let me tell you the story of my past client, Shannon. Shannon's case was a clear liability accident. Shannon had come to a stop due to traffic on the highway when a vehicle behind her struck a vehicle, pushing that vehicle into the rear of Shannon's vehicle. Unfortunately, Shannon did not take any photographs at the scene of the accident. This leads me to my first tip. Take photos at the scene of the accident if you're able to do so. Take photos of all vehicles involved as well. Luckily, in Shannon's case, we at least got photographs depicting the damage to her vehicle after it had already been towed from the scene, and her vehicle showed pretty severe property damage. That may not always be the case, however. I've seen several rear-end car accident cases where the vehicle rear-ended has very little damage, but the vehicle that struck the rear has extensive damage to the front of their vehicle. This is especially true if your vehicle is rear-ended and has a trailer hitch on the rear. In such a scenario, you absolutely want to get a photo of the other vehicle showing this was not just some tap on the rear car accident. Why is this? Well, it's been my experience that insurance companies will assess more value on car accident injury cases where the property damage to the vehicles involved is more extensive. Now, back to Shannon's case. In her case, the driver that started the chain reaction was the clear at-fault cause of the accident, and his insurance company admitted to liability. Shannon first called me months after her car accident. She had been receiving chiropractic treatment for her neck and low back, so she finally called me. When she first called me, I was worried she may have given a recorded statement to the at-fault driver's insurance company, however. You see, she had told me the other driver's insurance company had already admitted to liability and that she had communications with his insurance company. This leads me to my next step. Never give a recorded statement to the at-fault driver's insurance company. Recorded statements are a trap. You're not required to give the other driver's insurance company a recorded statement. Many insurance companies request shortly after your car accident to take your recorded statement over the phone. Do not fall for this trap. The insurance company wants you on recording saying things like your pain is just minimal. If you give your recorded statement just hours after your accident, that may be true, but it's not uncommon for your pain to increase in the days after the accident. The insurance company wants to lock you in as to what you are going to say about your claim and injuries so they can use what you say shortly after your accident against you later on during your case, especially if your claim has to go to court. There is simply no reason to give the other driver's insurance company the benefit of taking your recorded statement after your accident. The recorded statement can really only hurt your case, so don't do it. Thankfully, in Shannon's case, I learned that Shannon did not give a recorded statement to the other driver's insurance company. So when I first agreed to take on Shannon's case, my office began collecting Shannon's medical records for the treatment she had completed to date. When I got back some records, I noticed Shannon was doing the right thing. She was having pain and discomfort, so she was getting medical treatment. Shannon got chiropractic treatment for several months. She was not missing her doctor appointments. She even got an MRI, which indicated that she had disc protrusions at C4-5 and C5-6 levels. A disc protrusion, commonly known as a disc bulge, occurs when the spinal disc and associated ligaments are intact, but may form a bulge that will press on the spinal nerves. This condition causes pain in the neck, shoulder, and the arms. I also encouraged her to get another MRI on her low back since she continued to have low back pain. She got the low back MRI over 6 months after the accident. The low back MRI revealed a disc protrusion at L3-4 and a bulging disc at L4-5. Shannon was taking her health seriously. So this leads me to my third tip, and that is to do like Shannon did and get medical treatment if you are having pain and discomfort. I often speak with injured car accident victims that think they are just going to tough the pain and discomfort out and that the pain will go away eventually. This is not a good idea, not only for your health, but also your injury claim. If you are having pain and discomfort, get medical treatment. Medical records are crucial for any rear-end accident case. Medical records document the issues and pain you are experiencing. The more dates you go to get medical treatment, the more proof you have of the pain and suffering you were enduring following your accident. It's especially a great idea to get an MRI on your spine if you are having neck or back pain. MRIs can only be crucial in diagnosing the problems you are experiencing, but can also reveal objective injuries that you sustain that can dramatically increase the value of your case. So after your accident, I would highly encourage anyone to get chiropractic or physical therapy or pain management or any other medical treatment recommended by your doctor, and try your best not to skip appointments with any medical provider, because any significant time gaps in getting medical treatment will be pointed out by the insurance company as a way to diminish the value of your case. If you don't get medical treatment backed by medical records, even if you experience quite a bit of pain, you don't have much of any injury claim. Now, back to Shannon's case. After I gathered the rest of Shannon's medical records and bills, I made a big demand. I demanded in writing that the other driver's insurer pay out the insurance policy limits. They did, but we were not done. You see, Shannon had underinsured motorist coverage on her automobile policy, which allowed her to pursue an additional claim for her injuries since the other driver did not have enough insurance to cover her damages for her injuries. This was a good thing. After we settled with the other driver's insurance company for the policy limits, I next sent another big demand. I sent a written demand for the policy limits to my client's underinsured motorist insurance carrier. And this leads me to my fourth tip, and that is to make big demands to the insurance companies in your case. Do not settle for less. To give yourself a shot at the biggest payday possible, consider making a demand for the policy limits. Or if you know the other driver has huge limits that exceeds the value of your case, start your demand off with a big number, well over and above the value of your case. The only way to give yourself a shot at a fair and reasonable payday is to make a big demand. I suggest you do so and make your demand in writing, whether it be by letter or email. By making a big demand in your case, it sets you up for a possible big payday. So after I made the big demand to the underinsured motorist carrier in Shannon's case, the underinsured motorist insurer responded with an offer of only $22,000. I was confident Shannon's claim was worth more, however. So instead of wasting time negotiating further, I showed the insurer we meant business, and I filed a lawsuit, sticking with the demand for the underinsured motorist policy limits. And this leads me to my fifth and final point. If the insurance company makes you a low offer, file a lawsuit in your case. Lawsuits put pressure on the insurance company. They have to hire an insurance company defense lawyer that charges by the hour at a hefty price. Trust me, I know. As I said earlier, I used to be one myself. Lawsuits also take time and cost money to defend. It also puts pressure on the insurance company to make you a fair offer eventually, as all insurance companies have a duty to act in good faith, and they don't want to offer you less money than what a jury awards you at a trial should your case go to a jury trial, as that can create more problems for the insurance company. In Shannon's case, shortly after I filed the lawsuit, the underinsured motorist insurer finally offered to pay out the underinsured motorist coverage policy limits. If you follow the 5 tips I discussed in this video with your rear-end car accident injury case, you give yourself a shot at a big payday. But the thing is, just because you know the 5 tips I discussed in this video that could maybe lead you to a big payday following your rear-end car accident, you still may be thinking you really do not have a good idea of how to handle your car accident injury claim. And if that sounds like you, you should definitely watch this video about to pop up right here, where I give you a step-by-step car accident claim guide that is so easy that even a caveman can master it. Lastly, if you've been injured in Kentucky, remember to don't wait, call Tate.